A field of blue, with an animation revealing the seal of the Department of Homeland Security. 4th Annual Chief Procurement Officer Symposium, Session 3, Hot Topics in Procurement. Trina Graves introduces session moderator Sarah Todd and panelists Charlene Storino, Roger Hipp, and Rena Martinez as they participate via web camera in a discussion on procurement for the federal government. Below the panelists' video feeds, a presentation deck displays the topics for the session. An illustrated stage sits behind the panel, featuring branded graphics for the 4th Annual CPO Symposium and the seal for the U.S. Department of Homeland Security.
Welcome to our third panel, Hot Topics in Procurement, moderated by Sarah Todd, Director of Acquisition Policy and Legislation, Office of the Chief Procurement Officer for DHS. Sarah, over to you.
Thanks, Trina. And let's go ahead and hop to the next slide. We'll give folks a little sneak peek at the topics we're going to be covering. So thank you, everyone, for joining us. We certainly have a lot of material to cover, but first, let me introduce an amazing panel of professionals that I am privileged to work with just about on a daily basis. So we'll go ahead and go to next slide. We have with us today Ms. Charlene Storino, and Charlene is the Assistant General Counsel for Procurement Operations. She's been with DHS since 2015, and prior to joining DHS, she was an attorney advisor at ICE, providing procurement, fiscal, and administrative law advice. And Charlene is also currently an Army Reserve Judge Advocate General, or JAG officer, and has worked in a wide variety of procurement attorney positions. So welcome, Charlene. Thanks for coming. We also have Ms. Rena Martinez, and Rena serves as Assistant General Counsel for Policy Oversight and Specialized Acquisition in the DHS Office of the General Counsel. In that role, she leads a team of procurement attorneys that support several offices and components of DHS, such as the Office of Procurement, Office of the Chief Procurement Officer, my office, the FPS and CISA, Suspension and Debarment, and PARM. So Rena was also previously a procurement attorney with FEMA. Welcome, Rena. And we also have Mr. Roger Hipp, and Roger is an attorney for DHS Office of General Counsel, General Law Division, Acquisition and Procurement Law Branch. And prior to joining DHS in 2010, he served for 6 years as a trial attorney in the Department of Justice, Civil Division Commercial Litigation Branch. And Roger also has a wealth of private practice experience. So thank you, panel, for being here. Next slide, please. We're going to kick off with the elephant in the room, and that's, of course, cybersecurity. So some huge movements in cyber over the last year, including the new DHS Safeguarding of Controlled Unclassified Information, formerly known as Safeguarding of Sensitive Information. Just want to put a shameless plug in here for this topic. My team in APL has a recording posted on the implementation of this, which also affected the Appendix G, and we can post that link in the chat here too. So great info, check it out. But let's turn now to Roger for a topic also near and dear to me, which is the new evaluation factor that we're deploying in this space. Roger?
Thank you, Sarah. So big news, if you don't wake up every day and check sam.gov for announcements like I do, we just posted for industry to take a look at a summary of what we're going to do with the new cybersecurity readiness evaluation factor. So cybersecurity is one of those classic things where it's a journey and not a destination. So to tell you where we are today, I do have to take you a couple steps back in the journey to understand where we are and where we're going. In 2021, there was a major executive order about strengthening cybersecurity government-wide. We're still implementing facets of that. What we did last year to implement that was we took a selection of around 400 of our big contractors, and we administered what we call the cyber hygiene assessment. And this assessment tool is basically a questionnaire of around 25 questions based on National Institute for Standards and Technology tests for cybersecurity. It's a self-administered test, self-scored. They give you the NIST factor, and there's a box to check. You fully satisfy, partially satisfy, somewhat satisfy, have work to do, and so on. So we took those results from all those contractors, and then some very smart people at OCIO did some statistical analyses and came up with graphs and charts and bell curves to try and figure out where our contracting base is today and where we'd like them to go into the future. So the future is now. The problem with, or the downside of doing these cyber hygiene assessments was that they were backward looking. They took contracts that we already had and were trying to see where the contractor stood post award. But the directions from the president and the secretary are to make this a forward looking process. So that's where the new cyber readiness factor comes in. And in a very small nutshell, what we'll be doing is selecting some solicitations to pilot this idea, but it'll be sort of like the cyber hygiene assessments. We'll have the bidders complete the assessment. It will go into this tool by the portal, and then the folks at OCIO will crunch the numbers for us, adjust them statistically, and give us a score. The score is going to be high, medium, or low. And we're going to take that score and factor it into the best value determination. So that's in a nutshell. If I'm privileged to be the first person to explain this to you, I will be by no means the last. Sarah's got some ambitious ideas for how we're going to roll this out and explain it internally. We're going to explain it some more to industry. I'm helping put together something to help explain it to your procurement attorneys. But this is pretty exciting with any innovation. I mean, I can't think of the last time we saw a new evaluation factor. It hasn't been recently. We're going to learn some lessons and learn as we go. But I do think the desired end state, eventually, a few more steps down the cybersecurity path, is to have this a routine part of how we assess contractors for anything that is going to involve information technology. That's what the president and the secretary have told us to do. And I look forward to working with you all and helping us get there someday in the near future. Sarah, that's all for that.
Great. Thanks, Roger. Great info. Another topic in this space, it was a very clear message for all of us on the dangers of certain but very popular applications. So Charlene, tell us what's going on with TikTok.
All right, thanks, Sarah. Many of us have probably spent some time scrolling through TikTok videos on our phones or tablets, but hopefully we've been doing that on our personal devices that aren't connected or used for government business. Now, for those with IT devices that are owned or managed by the government or used or provided by the contractor under a contract, including employee-owned devices under a Bring Your Own Device program, TikTok or any other application developed or provided by ByteDance Limited shall not be installed on those devices, regardless of ownership. So how did we get to this place? Well, in February 2023, Office of Management and Budget, OMB, issued M-23-13, prohibiting the federal government from installing and using TikTok on government devices. Following that memo on June 2nd, an interim rule issued FAR 52.204-27, prohibition on any ByteDance covered application, including TikTok. This FAR clause must be included in current solicitations and new contracts and added to existing contracts via modification. Applies to everything, right? No dollar threshold. The ban applies across the board, no discrimination, government, contractor, and even contractor employee owned devices that they bring to use on a contract. Very limited exceptions, but you'll be in luck because DHS has a process in place to request an exception through your respective component CIOs. Now, while this may seem like overkill or cumbersome to monitor, the purpose of the rule is to protect government information and IT systems as part of a national security measure. If a CEO learns that TikTok or some other ByteDance application may be on a device, have them inform leadership, component CIO, and CISO representatives and let the vendor know immediately. Bottom line is you need to get your TikTok fix on an IT system or device that isn't used in performance of a government contract or as part of your work as a federal employee. Back to you, Sarah.
Thanks, Charlene. And we dropped a link to the interim rule on acquisition.gov in the chat there if anybody needs to go check that out. Now, Rena, looking forward, what do we see on the horizon that folks should be aware of in terms of new FAR rules?
Thanks, Sarah. Yeah, there's been a lot of movement in terms of new FAR rules in the cybersecurity space too. We've had several finalized rules, including FAR case 2020-11, implementation of Federal Acquisition Supply Chain Security Act orders, or FASCA orders, and that has an effective date of December 4th of this year. And for those who aren't aware, I know Roger is well aware of what FASCA orders means, but a FASCA order would require the removal of covered articles from executive agency information systems, or perhaps the total exclusion of sources or covered articles from future procurements as well. And covered articles could be malicious software or malicious hardware or counterfeit components, for example. And then there are two key FAR provisions that are out for public comment right now, and we've been working on these for quite a while. As you can see from the FAR case numbers, the first one is 2021-17, Cyber Threat Incident Reporting and Information Sharing. And the purpose of that rule is intended to increase the sharing of information about cyber threats and incident information between government and information technology and operation technology service providers. So basically, think breach and incident reporting by contractors. The second case is also 2021-19, and that one is standardizing cybersecurity requirements for unclassified federal information systems. And just as the title says, that rule is intended to standardize cybersecurity contractual requirements for the unclassified information systems. So both of those are out for public comment until December 4th. So December 4th is a big date in cybersecurity. Comments on those draft rules and also the implementation of the FASCA orders. Rule. So good things to watch for as the government protects itself from foreign adversaries and other bad actors, and also at all levels of the supply chain. Thanks, Sarah.
Thanks, Serena. So much that'll be impacting this community in the coming years. So I think really important for folks to be aware. Rena, you also have some information for us to share on what's going on at Department of Justice in this space and kind of why we should be aware of that.
Yeah, thanks. So the Department of Justice has what's called the Cyber Fraud Initiative. And that's a fairly new initiative by DOJ, and it's led by the Civil Division Fraud Section of DOJ. But they will be partnering, or they are partnering currently with the civil divisions of all 93 U.S. attorneys' offices throughout the country, and offices of Inspector General, the OIG offices, and various federal agencies as well. So it's a very collaborative effort. And with this cyber fraud initiative, DOJ is using the False Claims Act to pursue cybersecurity-related fraud by government contractors and grant recipients. And by the way, if you're not familiar with the False Claims Act, it was enacted way back in 1863 to fight fraud in Civil War contracts. So it's really fascinating that the government is responding to this very modern threat, very modern issue with this 18th century law that we have in our tool belt. DOJ is targeting contractors who put U.S. information and systems at risk by misrepresenting their cybersecurity practices or protocols, or knowingly providing deficient cybersecurity products or services, or knowingly violating obligations in their contracts to monitor and report cyber incidents and cyber breaches. So all of this work by DOJ and this collaborative effort is going to help level the playing field for those vendors who are following the rules of their contracts and government cybersecurity requirements, because obviously it might put them in a disadvantage if others are not following those and able to offer lower prices because of that. So very important there. And also, of course, it allows the benefit of reimbursing the government and taxpayers for the losses incurred because of this type of cyber fraud. Thanks, Sarah.
Yeah, excellent. I'm never dull in this space, and I think they've had a few pretty high-profile settlements. So, for contractors who have these cybersecurity requirements in their contracts, such as our DHS special clauses for safeguarding of CUI, really important for the vendor community to pay attention to that. So, Fascinating. Wrapping up this topic, I wanted to just let everybody know we are setting up a dedicated page on the APL website for cybersecurity, and we'll get that link out to everyone once it is live. But lots going on in this space and more to come, we're sure. So we thought it was probably time to have a dedicated place like we do for some of the other major topics. Great. Next slide, please. So domestic manufacturing, a true national interest topic, right? Bipartisan topic. Always a lot going on here. Serena, back to you again to tell us kind of what we need to know in this space from FY23.
Yes, and I promised to give Roger and Charlene a chance to talk. But the order we chose, I guess, has me up front quite a bit. But a lot to say about this topic. I know we don't have a lot of time, but there's been many changes in the Made America space, but most recent came from the Infrastructure Investment and Jobs Act, what we call EIJA, and that made the Make PPE in America Act. I remember in 2020, when I was first approached, I think in February of 2020 about PPE, and I had no idea what PPE meant, which is funny to think about now, because I think everyone knows what PPE is, personal protective equipment. But back then I was like, what's PPE? So we're all aware now of the supply chain disruptions and shortages brought to light during the pandemic. And while the intent of this act is to establish a resilient public health supply chain centered on domestic manufacturing of PPE, most needed during a public health emergency, such as what happened with the COVID pandemic. So we're talking about respirator masks, gloves, and gowns, that sort of PPE. To this end, the Act identifies new requirements, not only for DHS, but Department of Health and Human Services, and the Department of Veteran Affairs in procurement of covered PPE. These agencies are required to ensure any contract or procurement of covered PPE is a duration of at least 2 years, including all options, and the PPE, including all the materials and components that they're made of, is grown, reprocessed, reused, or produced in the United States. So in short, the items must be wholly domestic in that they're manufactured in the US using only domestic materials. So it's a bit complicated, but DHS implemented the Act through HSAR Class Deviation 2301, which is called Implementation of the Make PPE in America Act. And there's also a new HSAM subchapter in 3025. The HSAR deviation created a special clause and a special provision to put into solicitations for the covered PPE. There's some very limited exceptions to the Make PPE in America Act. Those are identified in the HSAM, and the process for obtaining those exceptions or waivers through those exceptions are there. But keep in mind, it'll have to be approved in the exception by the DHS CPO and also get reviewed by the Office of Management and Budgets Made in America office, which has a fun acronym. Every time I'm in meetings and people are calling the MEO, I always think of cats saying meow. So great acronym for that office. All this seems very complicated, but DHS was very clever, and we have a couple of strategic sourcing vehicles, one for nitrile gloves and another for the safety stock. So we've tried to simplify matters for CEOs, but if you have to buy PPE that is not covered by the strategic sourcing vehicles, please reach out to Sarah's team and APL or your procurement counsel, who should be able to help you walk you through that very complicated act. Thanks, Sarah. I think I have the most to say in that one.
No, always a good plug, right? When in doubt, CYA, call your attorney. No, but my team is also here to help everybody navigate through this. The best method is to use the mandatory for use DHS strategic sourcing vehicles. But when that doesn't work, let us know and we can make sure you're on the right track. I do see a question in the chat I will address really quickly. Walter asked about speaking to the proposed changes to the exempt list for non-domestic availability. We did include a proposal to add NBR, which is a chemical found in nitrile gloves, to the non-domestic availability list. There were several other, I think, proposals that went forward to add to the exempt list. I have not heard anything back. No decisions have been made on the rest of those proposals, but I did hear from OMB that there is zero chance they're going to put anything to do with PP on that list. So again, let us know, reach out if you've got questions, but we will wait and see if any of our other proposals went forward for that non-exempt list. So thanks, Walter. All right. So I will also take this opportunity to mention there is a microlearning on the APL website on this topic. I think it's the same link Tim posted earlier for our webinars. Check it out. Be sure to contact us if you have questions. Next slide, please. There were a number of really important protest decisions in FY23. And so, Charlene, can you share just a few of those with us?
Sure. So let's talk about 4 cases or 4 subject areas of some cases that came up recently. I'll talk about 1 case in each. All the case citations are on your screen, so you can read them online later or now if you want to, as we go through them. All right, so the first case deals with being excluded from the competition for failing to follow solicitation instructions. In Defense Solutions Group, as part of a proposal submission, offerors were required to comply with the submission of administrative requirements, including the submission of a DD-254. The solicitation indicated that proposals would be reviewed for compliance with admin requirements, and those that did not meet those would not be evaluated and considered for award. DSG was eliminated for not complying with the instructions for 2 requirements, one of which was the submission of the DD-254. Instead of providing the DD-254 in PDF as required, DSG sent it in Word as an image file, and they argued that all the information was in the form, so who cares? It shouldn't have mattered what format it was sent in. The agency said it did matter, and their instructions were explicit. They indicated that there was a reason why they wanted it in Adobe, to standardize it across the board and to view drop-down information in the form, as well as some other reasons. GAO said, hey, that sounds reasonable. If DSG didn't like the requirement to submit it in PDF, it should have protested that before the solicitation closed. Protesting now is too late, so they dismissed the protest. Instructions are important, so if offerors don't follow your instructions, and there is an important reason why your instruction says what it says, offerors will need to make that challenge before the solicitation closes, not when it doesn't work out to their advantage. In the second case, the protester alleged that the agency failed to conduct meaningful discussions. In BC Site Services, BCSS was not invited to participate in phase 2 of a 2-phase solicitation. In the solicitation, the agency stated that offerors had to put their best efforts forward in phase 1 and that the agency would reserve the right to conduct discussions. BCSS alleged that the agency held exchanges with other offerors, but did not have the meaningful exchanges with them because their exchanges did not discuss all the areas of their proposal that required modification, amplification, or explanation. During the agency had engaged in exchanges with some of the small businesses that were part of the evaluation and asked them to provide info to determine their acceptability. The agency argued that the requirement was not FAR Part 15, but FAR Part 36. It was a design-build construction contract, so discussions were not required. But the solicitation used FAR 15 language and referenced FAR 15 to discuss how the evaluation and discussions would take place. GAO disagreed with the agency and indicated that since other offerors were able to supplement or add information that was missing from their proposal, yet BCS was not, the agency did not engage in meaningful discussions with all offerors and as a result, sustained the protest. So make sure that if you treat all offerors equally, if you allow some vendors to supplement or add information to their offer, their quote proposal, that helps you make the decision on their acceptability, you do it the same for all of them. The third case deals with excluding an offeror from the competitive range because of its high price. In Sigma Inter-Albania Vienna Insurance Group, Sigma, who was the incumbent, was excluded from the competitive range due to its high price. Sigma argued that the other prices should have been found unrealistically low and that it should have expected to negotiate a price with them before it was excluded from the competitive range. Now, there was no language in the solicitation requiring a realism determination, And the fact that Sigma thought that the agency would negotiate first was a business decision that didn't pan out for them. Just because it was an incumbent didn't mean that it got extra points or special treatment. GAO sustained that protest. Offerors need to put their best foot forward up front and not expect agencies to conduct discussions prior to setting a competitive range, which typically happens after a competitive range determination, not before. And a realism, finding prices that are unrealistically low, only works if the solicitation says that's what you're going to do. All right, the last case is about evaluating JV experience. And Attain X alleged that the awardee's experience should not have been rated as high because the experience was related only to the minority JV member, not the managing JV member. Agency argued that the solicitation did not require references or examples from each member of the JV, so it didn't matter. But the SBA Act requires agencies to consider the experience in the individual members of the JV if the JV itself does not demonstrate its own experience or past performance. SBA regs say evaluate the work done individually as well as any work done jointly. So here the agency clearly did not evaluate the experience from all the members and mistook the experience for the minority member as the majority member. Agency's evaluation was found unreasonable and was sustained. When evaluating past performance or experience of a JV, remember you need to evaluate the experience of the individual members and that of the JV itself if it's available. You need all of them, not just some of them. So hopefully, right, all these cases all together will give you a few points that you can take back to help you in your future evaluation. So here's a few decisions to help you think about some things for the future time. And that's it. Back to you, Sarah.
Thanks, Charlene. I always remember lots of things when looking at through GAO cases and things you might have forgotten, and then always learning new stuff. So I think that's really helpful, great information. Next slide, please. Rena, back to you again, and then Roger, I promise we'll circle back. But I understand there's a new Acquisition and Grant Fraud Council program, and we can add a link to that directive in the chat. But tell us more about this program.
Yeah, thanks, Sarah. Yes, even the Office of the General Counsel had some big news of its own in 2023. So our instruction for the new OGC program was approved and signed by the General Counsel last spring. And the goal of the program is to coordinate legal advice and remedies involving acquisition and grant fraud as well, and improve coordination across the department and up to the General Counsel of DHS as well. We're trying to prevent silos from forming in response to acquisition and grant fraud, and instead foster collaboration and coordination by the various departments' legal offices. So in that vein, each DHS office and component currently has a designated acquisition and grant fraud counsel. And in some cases, there's more than one attorney designated as the acquisition and grant fraud counsel. We meet quarterly for training and for updates on the program, and as needed if there's an actual acquisition or grant fraud case to discuss. Anyone in the acquisition and grant workforce can reach out to their designated fraud counsel if they suspect fraud in a grant or contract, or they're just not sure, is this an indication of fraud or not, or they just need help in taking the next step. Maybe they're not quite sure. Should they reach out to OIG? Should they reach out to the suspension debarment official? And their grant acquisition and grant fraud counsel is there to guide them and advise them through that process as well. And we're working on getting information on DHS Connect. So, but I know Sarah put together a slide of the currently designated fraud counsel for you to reference as well.
Yeah, thanks, Serena. Can we go to the next slide? So we've got some POCs here for folks. As I understand, there's not a link right now up on DHS Connect with these POCs. So we'll get the slide deck posted on the ADEL site so you can find those in the meantime, and we'll get that link out when it's available. Yeah, I think this is really important because there's been some really interesting settlements in the space recently. There's been a lot of interest on the Hill. There's been draft legislation. There's been enacted legislation. There's an open FAR case. So I keep hearing calls for actions that's going to affect this community. And so that kind of dovetails really nicely into our next topic, which we'll go back to Roger for. So Roger, it seems like no procurement topic was untouched in FY23, including even responsibility determinations. And of course, we talked a little bit earlier about the new DORA bot that we're rolling out. And I think this is a really timely conversation for our workforce. But tell us a little bit about what's happening in this space. And we can go to the next slide. Thanks.
Sure thing, Sarah. So, speaking of fraud, I would say the elephant waiting right outside the room is what are we going to do with contractors who have been involved in False Claims Act cases? And the one that we're thinking about very hard is Booz Allen Hamilton, one of the very largest government contractors, not just here, but across the government. Last year, they settled the Ketam case for a whopping $377 million. The allegations involved misconduct that extended a decade from 2011 to 2021. The main allegation was that Booz Allen allocated indirect costs from non-government contracts to government contracts. And there were allegations to the effect that Booz Allen thought the government auditors would be too stupid to ever catch on. The surprise was on them. The whistleblower is a fascinating person. According to Washington Post profile of her, she is a Marine who served in Iraq, went on to get an Ivy League MBA. So why Booz Allen did not take her seriously when she tried to blow the whistle internally, I have no idea. But eventually she blew the whistle externally. DOJ said, thank you very much. We'll take the case from here. Her take before attorney's fees was $70 million. So that is powerful incentive to blow a whistle. And I'm sure that got a lot of attention. And as we see with the cyber fraud initiatives and the other DOJ initiatives that Rena was talking about, I would certainly expect an increase in activity on that because there's so much incentive and awareness right now for these kind of suits to happen. But the question is, what do we do about cases like this? And there is not a lot of guidance, I'm sad to tell you. There is the leading case that we've been thinking about is a 2014 case that did involve the agency, it involved USCIS. Some of you may remember it. The case is called FCI Federal. And the contractor we were worried about was called USIS. They used to handle most of the background checks for the civilian branch. We acquired those with an IEA through OPM. And CIS had awarded a contract to an affiliate of that company, not for background checks, for something else. But that scandal was in the news at the time, and the contracting officer did not consider that information as part of the responsibility determination. And it's hard to know what she should have done with that information because that case was still pending at the time. So even if she called DOJ, I don't know how much information she would have gotten had she done her more due diligence. But that award got protested, and GAO said, well, we're not going to tell you exactly what you should have done, but we know that you can't do nothing. You can't ignore allegations that you're aware of involving False Claims Act and related fraudulent conduct. So that's all we know for sure in terms of legal advice is that you can't ignore this information. You do have to consider it and do something with it. Beyond that, we're not exactly sure. The follow-up cases, the government has always won. But the problem with those is that in each case, it was sort of easy for GAO to agree that the government's responsibility determination was reasonable. So, for example, sometimes the False Claims Act allegations will be several years old. GAO says you can consider that. Sometimes the company reaches more of an amicable settlement with DOJ where they admit responsibility, they apologize, they have pledged to institute best practices going forward. GAO says you can consider that. Sometimes DOJ hasn't taken these cases. When these are filed, DOJ sort of gets a right of first refusal, and it can intervene and take over the litigation, or it can say, we'll pass on this one, and you can litigate it yourself. GAO has said you can consider that. So those are all sort of easy cases. The Booz Allen one and other situations you can imagine involving our contractor base are not nearly so clear-cut. Booz Allen in particular did not admit liability. They said, we don't believe we did anything wrong. We're just settling to avoid the cost of litigation and to put this behind us. So Rena and Charlene and I have collaborated on a memo that we've been circulating to within OGC about this. Whoever wants to make the first award to Booz Allen, you would expect them to get a protest, and they're going to have to make new law here, which is a hard thing to do. So we're here to support that. If you have any questions about this situation, please reach out to one of us. We've been talking with Sarah's people about maybe updating. There is a job aid on responsibility determinations. Maybe we can incorporate some of that advice into that in some fashion. But I think there will be an interesting case about this in 2024, no matter which way. So if that case happens to be you, best of luck to you, and we're here to support you. That's all.
Thanks, Roger. Back to my comment about working with this group almost daily. So yes, looking at what we need to do here in terms of how we can support. We had a question in the chat about what happened to the CO as a result of the fraud. Just want to be really clear, the CO was not involved in the fraud. So just make sure that that's clear, and hopefully that answers the question. All right. Thank you. Our last topic, some of you may have seen a new guide, and we'll go to the next slide, from OCPO in late FY23, providing some guidelines on awards for contractor employees. I know that we have sometimes a close relationship with our contractor personnel that work with us, but we need to make sure that we're sort of following some of these guidelines to keep ourselves out of trouble. So Rena, share with us a little more information about these guidelines.
Thanks, Sarah. Yeah, this was a great collaborative effort between OGC and APL, and I'm really proud of us for getting this out last FY. I'm sure a lot of attendees have had this question come up. Questions sometimes come to OGC, both ethics and procurement attorneys, as well as the acquisition community, on whether it's allowed or appropriate to give recognition awards to a contractor. So perhaps performance recognition like we do for federal employees, but to give something to a federal contractor employee. And with this guidance, we wanted to make clear that awards for contractor personnel should only be done in very rare circumstances. And if done, it should be very limited to honorary awards, and preferably maybe just a certificate of appreciation, but still only in very rare circumstances. Also, the guidance that we put out advises that whoever would like to possibly give recognition to a contractor employee coordinate with the contracting officer on the contract and all contracting officers that may have contracts with that contractor employer of the person that they want to give the award to. And also coordinating with legal counsel, both ethics and procurement counsel, this suspension debarment official or at your component or at headquarters, the SDO, and also the security office of your component or at headquarters. And the reason for this is just because one person working for a contractor or on a contract is perhaps giving outstanding performance and you really want to acknowledge them, you may not know what's going on with the actual contractor. So there could be a contracting officer out there who's considering terminating for cause a contract or default a contract with this contractor, and or there could be a suspension debarment referral for this contractor. There could be an investigation by OIG of this contractor, or even the person that you want to give recognition to. They don't always, they're not going to advertise that they're investigating someone. So it's important to coordinate so you don't undermine a contracting officer or investigator or perhaps litigation that OGC or your component counsel are working on for a contract claim or some other reason with this contractor. It's also important to keep in mind that it's the contractor employee's responsibility to incentivize their employees and to acknowledge their performance. For the government, we acknowledge outstanding contractor performance through the CPARS system, the Contractor Performance Assessment Reporting System. So that's the standard way that we do it. That's what the FAR requires. But if there is some exceptional or rare circumstance, please follow the guidance that is on the DHS Connect site now. Thanks, Sarah.
Thanks, Serena. Great information. Be sure to check out the guide if you haven't seen it yet. Just post it alongside our many other guides and job aids, again, on the APL page. So that concludes our panel. I see we're at time. So much great information. Thank you to our panelists. And thank you to the acquisition community. You all do so much to keep track of all that's going on and all of these things that come up new and turnover and new information. So DHS just has the best acquisition workforce in the federal government. You guys are truly amazing. Thank you.